If you're listening to this right now, you've either just recently been arrested and bailed out, or you've received some sort of summons to come to court, a citation from a police officer or sheriff deputy. A lot of times people are afraid to go to court. The first court date is coming closer and the anxiety just becomes more and more intense. But the first court date is usually the easiest court date to get through. The first court date is called an arraignment, and really all you do is show up with a lawyer. The judge will give your lawyer a sheet of the charges. It's called a complaint, and you will learn the charges that the DA or city attorney has filed against you, and your attorney will plead not guilty for you. We all know from the Constitution that you have the right to a speedy trial. If you're out of custody in California and you want to proceed on a speedy trial basis, that means the DA has 45 days to try your case. If they can't put their case together in 45 days, they have to dismiss, and again, because this is a misdemeanor and they only get one shot, your case would be gone forever. For in-custody defendants, it's the same rule except it's 30 days. So if someone is in custody and they insist on a speedy trial and they're facing misdemeanor charges, the DA would only have 30 days to put their case together, or they would have to let the case go, or the case would be dismissed. After your lawyer pleads not guilty to the charges, there are common practices in all jurisdictions in California for misdemeanor cases. So think of arraignment, where you hear the charges and when your lawyer pleads not guilty, as the kickoff. After a kickoff, everything starts from there. You have the right to proceed on a speedy trial basis, or you have the right to give up a speedy trial and proceed on a time-waived basis. The judge, after he or she accepts the not guilty plea and hears from your lawyer on the time waiver status, will set future dates. Some common future dates are a pretrial, where your lawyer gets together with the DA and sometimes with the judge, and the lawyers try to work out a plea bargain. A readiness conference, which is where your lawyer will show up and say ready or not ready for trial. In other words, the judge doesn't want lawyers showing up on the day of trial saying, "I'm not ready," because witnesses, juries, police officers, courtroom scheduling would all be inconvenienced if that were to happen. So a judge wants to hear ready or not ready before the jury trial date. And then, of course, a jury trial. Once a case starts, it only stops under 3 conditions. 1, there's a dismissal. 2, the defendant accepts a plea bargain. Or 3, the case goes to jury trial and the jury says guilty or not guilty. Those are the only 3 conditions that a case stops under. This information is just meant to give you a rough, basic outline of misdemeanor procedure in California. For more detailed information, you should consult with a criminal defense attorney who can guide you further through the process. When talking to an attorney and trying to evaluate, you should ask them, how often do you go to trial? When you go to trial, how often do you win? Not all attorneys are created equal, just like not all doctors are created equal. You want to be careful of someone who doesn't go to trial, who just settles every single case. DA's offices are going to be more afraid of somebody that goes to trial versus somebody that's known for pleading their case out. When you go to trial, that's having leverage in a case. The DA might go to trial and win. They might go to trial and lose. You never know what's going to happen at trial on both sides, so it's something that you need to think about very seriously. However, you do gain advantages of working with an attorney that does go to trial and that is known to go to trial, especially if that attorney has very good trial results like we do at Tully & Weiss. Thank you very much for your time and listening, and I hope this informational video has been helpful to you. Again, this is a thumbnail sketch. For further details and more in-depth discussion, I would suggest that you contact an attorney who specializes in criminal law. Thank you again, and I hope this helps.